Hi, my name is Suzanne Graves. I'm a local estate planning attorney. I've been practicing in the area of estate planning for the last 27 years. I am a certified specialist with the State Bar of California, and I'm here to talk to you about some estate planning.
Suzanne, why is setting up a family trust so important?
Setting up a family trust is important for several different reasons. Number one, when people accumulate assets, they want their assets to go where they want it to go, not where the state of California has determined it's going to go or where a judge says it's going to go. They want to keep control of their assets, and not only after they die, but while they're still alive. If they become disabled, they want to control what's going to happen. And I always tell clients that's really important because when you're still alive, you might know the difference. So you want to make those decisions yourself and be able to control things without someone else stepping in and controlling things for you.
Suzanne, and please define what's an estate.
An estate is anything that you acquire during your lifetime. It could be your personal belongings, it can be your bank accounts, your investment accounts, your 401ks, your IRAs, any real property that you own, investment properties, a business that you've acquired, any of those things consist of your estate.
Great answer. So, how does owning real estate, bank accounts, or other assets in a trust differ from owning these assets as an individual?
When you own them in a trust, when you create a trust, we retitle your assets into your trust name. So when you own them as an individual, you just own them, they're in your name. I tell people when you create a trust, you're still going to own your assets, but they're going to be titled in your name in your capacity as trustee of your trust. And why that's so important is that then if something happens to you, if you become disabled or you pass away, and you've named a successor trustee in your trust document, that person can step into your shoes and immediately start handling things for you without any court involvement.
Fantastic answer. And when should somebody establish their family trust? When is that important?
I would say two things are important. Well, actually probably three. One, if you're acquiring real property, you should have a trust because you are going to be involved in some type of court action if you become disabled or you pass away and there is no trust involved. Number two, if you have more than $150,000 in assets in the state of California, then you should have a trust because that's the amount that determines in the state of California whether or not you go through a probate or not. So once you reach that level, and most people who own a home in the state of California acquire that level once they own a home. The third thing is if you have minor children, you really should have a trust. If, a lot of times when people are just starting to have children, they think, well, I don't have enough money to have a trust because I haven't acquired much yet. But a lot of times what happens are these people, they go out, they acquire a life insurance policy to pay out to take care of their child in the event they pass away. And what happens is if they name their minor child the beneficiary of that policy, if they pass away when that child is still a minor, the life insurance company is not going to pay out, and not to that minor. So what happens is someone has to be forced to go into court, get a guardianship set up for that minor. And again, if they haven't done planning, they're not the ones determining who that guardian's going to be. It might be the court, and it might not be somebody they would choose. Then once that guardianship's set up, the court says, you know what, we need to protect this money. So what we're going to do is we're going to throw everything into a blocked account. Nobody can get it without a court order. So now, let's say that the minor has needs. Let's say they need braces. And so we can't just go in there and pull the money out of the blocked account. You have to hire an attorney. You have to go in, petition the court, get permission, tell the court the child needs braces, get the permission from the court to pull out the money. So every time that child has a need, you have that process to go through. And what happens is that life insurance gets drained by the court process, by payment of attorney's fees, having to pay the court costs, and it takes time to get through that process to petition the court, get in front of that judge. Take the other scenario, if you have a trust and you have a trustee managing that money, That minor needs something, the trustee can go right in and access it. Then when the child, let's say there is no trust, and we've set up that guardianship, and now the child's reached age 18. The court says, you know what? We're done with this. We've done our job now. Here you go, 18-year-old. Take your $1 million life insurance policy and have a good life. Well, I don't know about you, but I have 3 boys, and when my boys turned 18 years old, I would not want to just hand over a large sum of money to them. They're not mature enough yet. So when you have a trust, you can decide when that money is going to pay out to them. It doesn't have to pay out immediately when they're 18. But when you don't have a trust, or if you only have a will, the court's not going to regulate that forever. So when they turn age 18, they get their money, and that's it.
Suzanne, that's extremely eye-opening. Thank you for sharing that. So what happens to someone when they pass away with a trust in place?
If they have a trust in place, a lot of times people think, I have a trust, I don't have to do anything. That's not exactly the case. They still have to administer that trust. There's legal notices that need to go out. There's usually a final tax return that has to be filed, and taxes need to be paid. So there are things to do, but what happens when they have a trust is if they've got that successor trustee named and they've got all their assets titled into their trust, that successor trustee can step into their shoes and immediately start handling things, start sending out those notices, start administering that estate, and be able to distribute the estate out the way that you intended it to without being held up going through the court system.
Suzanne, you told us about what happens when someone passes away with a family trust. What happens when they only have a will or they have nothing at all?
Typically, if they have nothing at all, or if they have a will, they're going to go through a probate if they have more than $150,000 in assets. So if they have no will, the state of California has a plan for them. There's a statute that says where their things go. And if they do have a will, their will says where they want their things to go, but it gives them no avenue to get it there. That's one of the primary differences between a will and a trust. When you have a will, everything is still titled in your own individual name. When you have a trust, it's titled in your trust name. So what happens, let's say I had a will, I now passed away, and my 3 children, it said in my will, I wanted it to go to my 3 children. Well, if my 3 children decide it's time to put the house up for sale, okay, and so we can divide up the money, they're gonna go call a realtor, and when they call that realtor, they're gonna find out the title of that house is not in their name. So they're not going to be able to do that. So that's what forces them into that probate court. So they end up having to go through a probate. Now the biggest downside of probate is that it's very costly and it's very time consuming, and everything's public. And it really becomes important if you have a client who's a business owner. Oftentimes they don't want all the finances of their business to be public information.
Terrific. And you've mentioned probate quite a bit throughout what we've been talking about, estate planning and trust. What is probate in the state of California? Why does it exist, and how can someone avoid probate?
Probate exists because everything's titled in your name, and we have to have a way in order to get it out of your name. So in order to do that, if something's titled in your name and now you've passed away, you can't sign a deed anymore. So what happens is you have to have a judge and a court order in order to get the assets down to the people it's supposed to go to. So I tell clients probate really is a court supervised transfer of assets. And what happens is you have to go in, someone has to petition the court, become the administrator of the estate. Typically they will have to post a bond. Because the court needs to make sure that the administrator isn't going to run off with all the money, and there's a process that they have to go through. Oftentimes, if there's a sale of a home, that has to have court approval, and it takes a while to get through that probate system. And the average in the state of California, it takes about 18 months to get through it, and sometimes it can go much longer. Can go a little bit shorter, but usually not much shorter, because there's a process where you have to give notice to creditors. Creditors have to have an opportunity to file a claim. those kinds of things. But what you end up with at the end of that probate is exactly what you're after, and that is a judge ordering the assets down into the names of the people that the assets are supposed to go to. So that's either your beneficiaries under the will, or if you have no will, it's whatever is pursuant to the California state statute because you did no will.
Suzanne, this has all been very informational. Can you explain to us why probate exists in the state of California and what it entails?
Yes, probate exists because it's really a titling issue. If something's titled in my name and I pass away and my children go to try to put my house up for sale to divide the money between the three of them, they find out that they can't do that. When they contact the realtor, they find out, wait a minute, that deed's not in your name. You have no authority to list this property. So what that does is that forces them into the probate court. And probate is really a court supervised transfer of assets. And so what they have to do is someone has to go in, petition the court, be appointed as administrator of the estate. They have to give notice to creditors. They usually have to post a bond to ensure that they don't run off with all the money. Sometimes there's a sale of the house that goes through the probate, but eventually at the end of that probate, they get what they're after, and that is a court order coming down from the judge ordering the assets into the names of the people that you would want it to go to. And so it's either under a will, it's the people that are named as beneficiaries under the will, but if somebody's done no will at all, then the state of California has a plan for them, and the statute tells us where that property goes.
Wow, so it's really the state dictating by the laws that are in place how the assets are going to be disposed and who's going to share those assets.
That's correct.
Wow, that's a very complicated process. It sounds time consuming and expensive, is it?
It is. That's the two biggest downsides of the probate. It takes a long time to get through a probate in the state of California. On the average, it runs about 18 months from beginning to end. Sometimes they can go much longer. Sometimes they can go a little bit shorter if there's not a lot of assets and not a lot of family members creating problems. But one thing you have to remember when you're going through a probate is it is a forum where people can show up and object to things, and then things get continued and delayed. And so that's normally how things can extend out way beyond the 18 months. If someone's showing up and objecting, and the court has to now analyze what their objection is and make a decision on that, that delays things. It's also very costly in the state of California. All the attorney's fees and the executor's fees are statutory in nature. They're set by statute. They're based on a percentage of the estate. To give you an idea, $100,000 estate in the state of California is $4,000 in attorney's fees, another $4,000 in executor's fees, and a couple $1,000s in court costs. So you're looking about $10,000 to probate a $100,000 estate. And the larger estate, the more those fees go up.
Wow, so you're looking at 10% or more plus 12 to 18 months just on $100,000.
Correct.
That is a lot of money. So Suzanne, tell us, how can people in the state of California avoid this probate process entirely and not be hit with those costs, that extended time by being in court because you're a probate, and just have a more easier transaction to transfer their assets when they pass away?
Again, it goes down to a matter of titling. If they were to create a living trust, basically what happens is there's a retitling of their assets into their trust name. Now, sometimes people get confused. They get a little bit nervous when I talk about retitling all their assets. But it's still going to be held in their name, but now they're going to hold it in their capacity as trustee of their trust. And so what happens is that now, if they become disabled or they pass away, they've got a successor trustee named inside their trust that can step in and start handling their assets because that asset's been retitled. And we no longer have the need for that probate court when we have that retitling occurring inside a living trust. So their successor trustee can step in, start handling things pursuant to the instructions of the trust without any court involvement, and they can do that immediately.
Oh, that's really powerful. So if someone were to set up a family trust, that's not just the retitling of the real estate, that's probably like bank accounts, security accounts, I mean like mutual funds or stock accounts,
Right.
maybe even cars and recreational vehicles too.
Yes, it's usually any major asset that they have. So it's retitling of their bank accounts, their investment accounts. It's also retitling of any real properties that they own, anything like that. That has any significance and value is retitled into their trust name.
So these estates can really add up once you start like allocating all these assets that people have.
That's correct. And the other thing that we look at is life insurance. We usually designate the trust to be the beneficiary of the life insurance. And there's a couple of reasons for that. Number one, if they have minor children, we don't want to have to set up guardianships in the courts in order for the minor children to access those assets. But the other reason is oftentimes we build in certain protections for their children if they're minors or not. Creditor protection, divorce protection, those kinds of things. And if we've got those kinds of protections written into the trust, if we name the trust the designated beneficiary of the life insurance, then that money can gain those protections.
So really, it's about creating an efficient vehicle to hold your assets in, so you don't get locked, your heirs don't get locked up in court. It saves them on time and money and potential headaches.
That's right.
All right, perfect. Well, when we were talking earlier, Suzanne, you had mentioned that there are 3 essential items for proper estate planning. Do you mind sharing those with us again?
Sure. The first is working with a counseling-oriented attorney. One of the things that I tell clients is I feel it's my job to lay out options for you, because if I don't take the time to lay out those options, you might not know that those options exist. And so I don't really believe in a fill-in-the-form trust or a one-form-fits-all. Everybody's assets are different, everybody's family situation is different, and so we need to look at what it is that fits that particular client and lay out the options so that they know those options exist, and then we can work together to determine what's the best fit for their family. The second thing is making sure that estate plan is updated. People have a tendency to go, gosh, I finally got that living trust done. Now I'm going to go stick it up on my shelf for the next 20 years and not look at it ever again. Well, that's a big mistake, because if you look back over the last 20 years, there's a lot of things that change. The laws change, your assets will change, your family situation will change, and my experience as an attorney will change. So you want to be on some type of program where that trust is being looked at least annually to say, has anything changed this year? Do we need to incorporate those changes in? Otherwise, you'll end up with a trust with assets that have all changed, nothing's titled in the trust name, and then there's problems when something happens to you because that hasn't been kept up with. The third thing is being aware that even though you have a living trust, there is things that need to be done after a death occurs. And so what you want to do is contain those back-end costs. And a lot of estate planning attorneys never talk about the back-end cost of things. And there is a cost, but if everything is done properly and that estate plan is properly maintained, then you're going to control those back-end costs and keep them lower. So I always tell clients, when you have a trust, you're still going to have some back-end costs and some trust administration that needs to occur, but you're not going to have the expense that you have with a probate, and it's not going to take the length of time that a probate takes.
So proper estate planning, just to kind of recapitulate everything, it's one, finding a counseling-based attorney, estate planning attorney like yourself. 2, it's about annual review because things change, right? We can acquire assets, lose some assets, laws change, and our attorney's experience will change and evolve too over time, right?
Right.
And then the third thing is preparing for cost mitigation on the back end when, the trustees do pass away.
That's correct.
Perfect, perfect. Well, Suzanne, this has been amazingly informational. Thank you so much for taking some time and sharing all this information with us. So please tell our viewers, how can they meet with you to start planning their family trust?
Well, we have an office in Upland. We're at 1317 West Foothill Boulevard in Suite 245 in Upland, California. And our phone number is 909-981-6177. And if they'd like to set up an appointment, all they need to do is call. We'll schedule them an appointment, and then we'll send them our personal information form to fill out so they can bring that to their first appointment.
Perfect. Thank you so much, Suzanne. It's been a wonderful experience.
All
Appreciate
right,
it.
you're welcome.